Further hearing in the appeals of Huawei and others.
Yes, Mr. Howard.
Yes. Just before I begin, can I just say something about timing?
Yes.
The appellants had agreed that they would have until 1 o'clock today. It is possible that we will run over. If we do, then we'll eat up some of our time. My Lord, and just so you know what I'm going to be covering this morning, I'm going to complete my submissions on the central point about the grant of injunctions. I will then address forum non-conveniens, which is an issue, I call it forum non-conveniens, the forum issue, which is the conversant issue. And finally, I will deal with what is a standalone point which applies to Unwired, which is the non-discrimination point. So turning back to the central point, in our submission, however you approach the case, whether through the lens of ETSI or domestic law or both, ultimately it comes down to this. Is an injunction to restrain all of an implementer's standards compliant products in the UK an appropriate and proportionate remedy where it's willing to take a license under all of the asserted rights in the UK and indeed pay extra for that by reference to an uplift for inconvenience, which is what Mr. Justice Burse's settled UK licence does, but wishes to remain free to subject to proper scrutiny both the existence and the valuation of the alleged rights elsewhere. And in our submission, the answer to this is no, it's neither appropriate nor proportionate, and you get there both through the lens of ETSI and English domestic law, and indeed looking at them together. Now, can I just make some further observations about the nature of the injunction in this case and how it actually would operate? The injunctions granted to UP and sought by Conversant would shut down substantially all of a telecoms implementer's United Kingdom business. And as you know, that's not just in handsets, but also in other equipment, because all of that equipment has to operate in accordance with the relevant 2G, 3G, 4G, and just coming in 5G standards. The whole point of a standard is there's no possible design around, so the same would apply to an injunction granted against Apple or anyone else. The effect of the injunction is to bar any equipment manufacturer subject to the injunction from selling standards compliant equipment. Now, the next point to note is the injunction, the effect of the injunction or the nature of it is not confined simply to preventing use of the patents in question or indeed any specific invention protected by a patent. Paradoxically, the injunction would prevent the use of standard essential patents of others, and many, many, many others, many more than it would protect those of the patentee. Mr. Justice Burse's on his findings, in the UK there were several hundred SEPs of potential relevance. Now, each must be used by manufacturers, but in UP, in Unwired Planet, Mr. Justice Burse found that Unwired Planet had, at best, 6 which were potentially essential. Only one, in fact, had been found to be truly essential. Now, this is an injunction which, therefore, we would suggest is highly disproportionate in any way one looks at it, because it excludes use from the whole of the standard and sale of many other things which have got nothing whatsoever to do with the standard, such as cameras attached to the phone and so on. Now, this point is important both for your consideration of ETSI and the approach in domestic law. ETSI intended to make the standards available to all and to stop holders of SEPs keeping people out. I ask rhetorically, could it really have been intended to keep an implementer out of the UK unless he pays for foreign declared SEPs, which may not be SEPs, and where his only entitlement to payment is in respect of actual SEPs. Now, it's important to constantly bear in mind everyone accepts that there is no such thing as a portfolio right, and equally there is no such thing as an international patent. I would remind you of what was said in the TCL case, which is in A8. A8, tab 136, page 9205. No. Sorry, I've given you a false reference. Tab 136. Yeah, sorry. This is a decision of the US District Court of California, and at page 9205, at the top of the page, is an explanation of how ETSI works, and just above the underlined the mechanics of ETSI, just above from that, it says, as is clear from this definition, ETSI does not grant rights to IPR, and the FRAND obligation is not a supranational patent. Instead, the FRAND undertaking is to be expressly interpreted as an encumbrance on the IPR where applicable under the laws of the jurisdiction. We would suggest that that's an entirely accurate summary of the position. Now, the judgments below in our submission effectively make a single SEP into a super patent, allowing you to restrict access in the jurisdiction of that SEP unless you pay for disputed foreign declared SEPs. Now, in our submission, that is contrary to the purpose of ETSI, and it is also then an odd use of English injunction power. Now, I misspoke when, just on the facts. There are two SEPs that have been found in the Unwired Planet case. It doesn't affect the principle of what I'm saying. The next point is that the injunction in this case would have the impact I've described, no matter how trivial the patent in question was to the operation of the standards. Some SEPs are such that manufacturers have to provide for options, but these are never used in practice. But on the respondent's case, these provide a platform for an injunction, even though they may never be used at all. The fourth point I'd make under this heading is the commercial impact on a business like Huawei's of an injunction, which has to operate in accordance with standards, would self-evidently be massive. But the point goes far beyond Huawei. The approach applies to any manufacturer of standard essentials equipment. The respondent's case is that this is not a feature even peculiar to ETSI. It applies to any telecommunications standardization, indeed any standards process. So it would apply, for example, to video communication standards. An injunction is of massive coercive effect. That is particularly so when it's made against an undertaking with an established business. So for these MPEs who've acquired these splinter portfolios, Samsung, Apple, Huawei, and other major manufacturers are in the frame. Now, how can a manufacturer avoid the consequences of the injunction? On the approach of the Court of Appeal and Mr. Justice Burse, it can't, except by submitting to a global license, including in respect of disputed foreign declared SEPs, which it considers invalid and wishes to litigate in the foreign court. Once there's a valid and infringed UK patent, it carries with it an automatic right on the respondent's case to claim payment in respect of this global portfolio, regardless of whether there is a single valid parallel right to those actually asserted in the jurisdiction here. And so the right that they seek to assert doesn't, as I think at one point the Court of Appeals judgment seemed to indicate it, they're not just seeking licensing of families of patents, it's of any declared SEP that they have in their portfolio. In fact, it's worse than that, and again, this is something important to understand. It is potentially a claim over any patent which the proprietor owns or may acquire, which it asserts is essential. Because what we know has happened, and it's described in Apple's submissions, Unwired has brought proceedings against Apple relying on exactly the same patents as are the subject of this case. In other words, having secured the golden patent, they have sued. But what they've done is they've gone out and bought more patents and added them into their portfolio. They're completely untested, but their position is don't test them, indeed the English court can't, just force a global license for the lot. You have to take a job lot, and as Apple says, the claim is potentially larger than $8 billion, because Unwired Planet have said the license should take account of all patents subsequently acquired as well. Now this really is, in our submission, a rather extraordinary state of affairs. The effect of the injunction sought in these cases is not just to protect the rights in suit. It's not even just to protect patents of the same patent family. It is to secure a claim in respect of a completely untested and potentially completely invalid or not essential basket of later acquired rights, which may not even have belonged to the proprietor at the time the UK action was brought. Now, this is not only in our submission entirely inconsistent with ETSI, it's entirely inconsistent with domestic law concerning injunctive relief.
When you speak about a patent family, as mentioned in ETSI, does that patent family extend to overseas patents as well as UK patents in this context?
Yes, it can, but the important thing is to remember, and this is clear in all the authorities, that just when you talk about a patent family, all that means is you have patented in another jurisdiction the invention, but whether it is a valid patent is a question of the law of that jurisdiction. So it's been said in this jurisdiction, for instance, the fact that a US patent has been found valid in the US courts doesn't mean that a family member is valid in this jurisdiction. It's a matter for the courts of this jurisdiction to determine matters. That's so even when you're dealing with United States and United Kingdom, where we have a common language and so on. But in China, of course, the patent language is Mandarin, and the question of analysis of what is properly covered is going to be particularly susceptible to Chinese principles affected by the language and so on. And so merely because you establish, in this case, one UK patent or two UK patents, it tells you nothing about the family members.
Well, I understand that submission, but whether that achieves a fair balance between the IPR holder and the implementer is the question, where the technology has been established in one jurisdiction and similar technology has been patented in another jurisdiction. Your position is ETSI ignores the existence of the patent family and says the implementer can challenge jurisdiction by jurisdiction.
My submission is ETSI is not doing anything different to what is the position already under national law. I mean, for instance, if you take the position of a patent family and you go for an injunction, forget Etsy for a moment, take a pharmaceutical position. You have a patented drug, and you go in the United States to restrain infringement. The fact that the United States court finds that that patented drug is validly patented and gives you an injunction in the United States doesn't tell you anything about whether the United Kingdom court will. And the United Kingdom court might well look at it and say, actually, no, we don't think it is, or China, wherever it is. And so, and in our submission, Etsy wasn't saying that in any way disrupting that. Now, we looked yesterday at the terms of the settled global license. The terms of the settled global license, as I've explained, in practice would render challenges to the patents in foreign countries either completely or largely irrelevant. Now, I don't want to go back through the detail of that, because I think everybody's understood that. But one particular point I would draw, well, the 2 points I drew attention to, is that the settled global license, one effectively, well not effectively, meant that royalties on Chinese sales were payable irrespective of any Chinese litigation. That's the first thing. The second thing is back damages or back royalties are payable irrespective in all cases. Now, we say this was wrong for a number of reasons, but leaving all else aside, damages for the past, as Mr. Justice Burst assessed, are UK damages. We would suggest it is entirely wrong to fashion an injunction to require payment for the past of what are not UK damages, and in order to secure more than the UK tort allows. Now, the next point, which I remind you, is that the English court's approach was to look at comparables. Now, other courts in other jurisdictions have a different approach to determining what is the appropriate way to assess a reasonable royalty. And so one's left with the question, on what basis is it appropriate for an English court to be assessing or to be ruling on the appropriate royalty rate for disputed patents which are here Chinese. In our submission, there isn't. Now, it is true that in a consensual global settlement agreement, parties may choose, for instance, to adopt a broad approach, may adopt whatever approach they like, and they may not be following the law. That's the nature of consensual agreement. But in court, or the court's task in our submission, is something very different. When it's settling a license in a dispute of this sort, it's settling terms which in our submission have to reflect the matters which are properly before it and properly within its jurisdiction. And whatever approach the English court may say is appropriate for UK SEPs, in our submission there's no reason in principle that it should be imposing that on foreign SEPs, particularly where they are in dispute. Now, turning in more detail to the law,
just before we do this, I'm sorry to interrupt your train
No,
of
I
thought,
welcome
as it were.
interruptions.
But it's just, while we still remember the point that my Lord Hodge raised a minute ago, I see, when one turns to the Etsy documents in Appendix 9,
Yeah.
I'm afraid I don't know the MS numbers, but they start in the hard copy at 3160 in the Rules of Procedure, and one sees in Clause 4.1 the obligation to notify Etsy of IPR which might be essential.
Yes.
If a proposal is adopted, in other words, a proposal for technical specifications. And then 4.3 says that the obligations pursuant to Clause 4.1 are deemed to be fulfilled in respect of all existing and future members of a patent family, that being an expression defined on page
2166.
2166, if ETSI has been informed of a member of the patent family in a timely fashion. And then when one gets to the licensing obligation in clause 6.1, one sees there that this is envisaging a situation where a standard or technical specification has actually been adopted, and there is is IPR which is essential to it. Then ETSI is to request, the Director General is to request an undertaking from the owner of the essential IPR that it's prepared to grant licenses on FRAND terms. And then 6.2 on the next page, an undertaking pursuant to clause 6.1 with regard to a specified member of a patent family shall apply to all existing and future essential IPRs of that patent family unless they've been expressly excluded. So the undertaking would apply to members of the patent family, provided they are themselves essential IPR.
That's, your Lordship is entirely right, that's the critical point. And you can't, and you then go back to what do you have a right to be paid for. The fact that you establish the UK patent doesn't give you a right to be paid for something which is a Chinese patent which is in the family, unless that is in fact a SEP.
Yes.
And there's nothing in ETSI is actually just entirely simple and consistent with the normal position.
Yes. And can I just explore a little bit more? In 6.1, the idea, the concept is of essential IPR relating to a particular standard or technical specification. So, so if you have IPR which is essential for a standard relating to one aspect of the technology, then there's an undertaking to license that. So you're not undertaking to license other IPR which may be essential but relates to a different standard or a different technical specification.
Well, that would be a separate.
It would be a separate issue.
Yeah.
Yeah. It would be a separate license, or at least it.
Yeah. And what you're not undertaking to do is to license other patents which are not essential patents.
Yes.
So you retain, I mean, for instance, you may have a patent which is a valid patent, but which is not essential in the sense that it's been incorporated in the standard.
Yes.
But it may have something where somebody says, well, actually, that would be a nice must-have for some reason in relation to the phones or something else. Well, there you're back in your normal position. You haven't, because you don't have to use it. The important point about all this standardization is anybody who wants to manufacture and sell a phone on the 4G standard has to comply with it, and you are treated as using all essential, all SEPs that relate to that standard.
Yes. So if I can draw an analogy, if you're an implementer and what you're interested in is a violin, as it were, you don't have to take the whole orchestra.
And that goes back to a debate, or not a debate, questions from my Lord Briggs yesterday. The implementer, what he can't do, for instance, let's say somebody comes along with 10 UK SEPs. If he says, well, I don't want 9 of those, they all relate to the 4G standard, he can't do that because the owner, it can go for an injunction in respect of all 10, but he's got to prove they exist. Now, of course, or at least to get paid for them. He may have one, which would give him an injunction in respect of that one. Unless you pay for that one, you'll be excluded. But if he wants you to pay for the 10, then he has to establish it. Now, that, in my submission, there's nothing really particularly surprising about that. I mean, you normally get paid for rights you have, not for rights that you assert.
Yes, thank you. I'm afraid I interrupted.
No, as I
your
said,
argument.
I welcome the interruptions. Now, the point I was going to make was that you will have seen, and indeed I think there was an exchange which you had to rule on, where we had referred to the decision of this court in the Coventry case. Now, this case does not need to consider what the appropriate position is in English law following Coventry on one step and the comments in Coventry about Shelfer in the run-of-the-mill patent action. We're not in a run-of-the-mill patent action, we're in a SEP case, and the critical features of a SEP case are that in a SEP case, the patent is essential to a public standard that all are entitled to operate, and all are entitled to use, and indeed must use if they want to sell the products. And secondly, the undertaking to allow such use. Now, what the position is in other cases where you have a patent and the extent to which Coventry affects the approach that the patent courts have taken may be a debate for another day. We don't need to resolve that today. But the whole reason for having an ETSI undertaking is to ensure that proprietors of SEPs are confined to a monetary remedy. And the purpose of the undertaking is to substitute monetary remedy for injunction. And that ensures the patentee cannot sue its monopoly, cannot use its monopoly to stop development and use of the standards. Now, as I said yesterday, we don't dispute that in principle there may be circumstances where an injunction could still be granted if enforcement, if for some reason the damages were unlikely to be paid and use was still being made. But that is likely to be extremely rare. Now, the next point I make is, again, some of these points are rather simplistic, but they are important. We say it is the purpose of an injunction, an English or UK injunction, is to protect UK rights and not to protect foreign rights. And the Court of Appeal at paragraph 52 referred to Lord Justice Aldous in Coflexib, where he said that the injunction must equate to the statutory right given, and we suggest that that is entirely correct and the normal position. So in our submission, you can't, in the domestic setting, put forward what are foreign rights in order to justify an injunction, still less where we're talking about a final injunction and those foreign rights haven't been adjudicated and can't be adjudicated. And that then takes me to the point that in our cases, damages in substitution are appropriate rather than an injunction. And the damages that the UK court would assess are the UK royalty. And we rely on, one, we rely on common sense for that. Secondly, we rely on what my Lord Reid said in the one-step case, that damages in substitution for an injunction are a monetary substitute for what is lost by the withholding of the injunction. That's paragraph 95.3, and it's A3 tab 50 MS 5656. And damages in this field serve to compensate for the future wrongs which an injunction would have prevented. And that's what Lord Justice Millett said in Jaggard and Sawyer, which is A2 tab 30 MS 5000. Now, in our submission, there should be a principled correspondence between damages for the past and damages for the future in substitution for an injunction. As was recognised in one step, there can sometimes be a debate as to whether in a given case the approach to the assessment of monetary compensation, whether it's on the basis of loss, the user principle, loss of profit, negotiation and so on, might be different for the past and might be different for the future. But the mere fact that you can have that possibility, as your lordship, my Lord Reid said at paragraph 47 in one step, doesn't mean that where you've recognised damages for the past or a UK royalty, the damages that would be the appropriate substitute for the future would be anything other than the UK warranty, UK damages. And the dividing line on this, we don't, I think, need to turn it up again. It comes out of the approach of the Court of Appeal in particular at paragraph 111, where they regarded it as a legitimate purpose of an injunction, and I quote, to secure the payment of all the royalties to which the respondent is entitled in respect of Huawei's activities in the other countries in which it carries on business. And that, firstly, it begs the question as to whether they are entitled, and the English court's not in a position to say that. But in this area, the English court is misusing, with respect, its injunctive power, because it's using the injunctive power to enforce payment of not even actually rights, but potential rights in a foreign jurisdiction. And in our submission, one of the things that has gone wrong here, I mean, we say this is the court's an excess of enthusiasm, if I can put it that way, to be polite, but it's exceeding their jurisdiction. But if one actually asks, well, why are you doing this, when the proper course for the patent owners is to sue on their foreign patents in the appropriate jurisdiction and claim the relief, in this case in China, that the Chinese court is able to give. And one point that one mustn't lose sight of, this is not a case, firstly, where anyone is saying, for instance, in relation to the Chinese courts, that you can't get justice there. But even if you were asserting that, it would actually be a nonsensical assertion, because this isn't a case where you are talking about, for instance, say parties to a contract, say, well, I don't want to litigate that in Ruritania because the other party is very close to the Ruritanian courts and I can't get justice in relation to our private dispute. A patent is a monopoly granted by a state. If the Chinese state or the USA or anywhere else says, actually, you haven't got a monopoly in China, then there's nothing wrong with that. It's just their view of the position. Or even if you thought there was something wrong with it, it's not a matter for this court. That would be a sort of matter that has to be dealt with through the WTO and other similar organisations.
Can I just ask you to
Yes.
unscramble a moment? Because all of this is built on the submission that there shouldn't be an injunction at all, there should be damages, and the damages should be the UK royalties. How do you calculate those damages? They're not past royalties damages, are they? They're future royalties damages. The injunction would give the option not to use this market and therefore not to have to pay any royalties.
That's
so
right.
how is it fixed?
Well, for the future.
Yeah.
Well, the damages for the past are a royalty, which is a percentage of the average selling
That's
price.
for the past, but
For
the injunction is intended to regulate the future.
Yeah.
So what about the future?
For the future, and Mr. Justice Arnold, as he then was, I think, addressed it in HTC, was it? HTC. And he said there are two ways you can do it for the future. And this would be conventional in any case. say I am breaching some right of yours, and the court says, well, you're somebody who only wants to be paid compensation, and I'm going to be using it for 5 years into the future. One approach is the court can say, well, I have to assess today, and I'll do it as a lump sum, the value of that, i.e. the damages for the future. Another approach where you say, well, that's not really satisfactory because things change, is that the court can set a running royalty and where it can review the position. So that's what Mr. Justice Arnold suggested in the HTC and Nokia case.
If you go back to Lord Shaw in Watson Laidlaw, this is effectively negotiation damages. He says, looking to the future, you can assess what would have been paid for a license to use the intellectual property rights.
Yeah, I mean, I entirely agree with my Lord Reed's point, and to pick up my Lady Black's point, of course, in this case, what the court has done by reference on a global basis is set a license for all the world. The difference between us is we say, no, you shouldn't have done that. You do a similar exercise for the UK. And although when you look at the license, you think, oh, there's lots of complicated things here, what is one really talking about here? One's talking about the royalty rate. And the royalty rate in this area, the way that is calculated when you use the top-down method, is it's determining what is the total royalties that should be paid for SEPs in relation to, say, 4G phones. So that's why you count up the total number. But you do two exercises. You say, right, there are 2,000 SEPs that relate to, say, the 4G standard. And then what you have to do is decide what is the appropriate royalty for that 2,000 in relation to the average selling price of a phone. And so there's then a debate, which you'll see, for instance, in China, I think they come out at something like 4.5%. Mr. Justice Burse outside of China took a different percentage, but that's an assessment that's made. But these are just ordinary assessments. But an important point is the approach in different jurisdictions may be different. Now, and the approach that I have been commending to you is an approach which in our submission is entirely supported by English authorities and is also consistent with the approach in the United States courts. Now, in this, under this heading of damages, I also remind you of the dicta of Lord Sumption in One Step at paragraph 119, where he said that the patentee doesn't have an interest in the observance of his patent exceeding its financial value. Now, where you step outside of cases, outside of a set case, one can see that how you assess the financial value and what it is may be more problematic. But where you're in a case where you are a licensor, and that's all you do with your patents, and indeed you're bound to license them, you are in a situation where all that you want is money. And those were the words of Lord Justice Lindley in Shelfer. So even in Shelfer it was recognised where all you want is money, an injunction may well not be appropriate. And we say the Etsy undertaking doesn't change anything. Now, as to...
and I suppose we see that, for example, in the Argyll case on injunctions in the House of Lords. And is that really what lies behind the eBay decision in the US Supreme Court?
Well, the decision, yes. I mean, the eBay decision is recognising that you shouldn't be starting in a patent case by simply saying, I injunct, because there are many situations where all the patent owner is really interested in is money. And you're seeing, and therefore in eBay, the US courts have now adopted an approach. It doesn't mean you never give injunctions, but for instance, in these sort of cases, these set cases, you almost certainly would not.
I mean, you see, it's very well, it's focused, the debate in Argyll, where I think it was Lord Brown Wilkinson, I think, took the view that breaking the law is wrong, and therefore it should be injuncted. Yes. So it's a law enforcing a moral principle, really. Whereas Lord Hoffman and the majority took the view that where all you're talking about is money, the question is whether damages would provide an adequate monetary remedy.
What this actually reflects is the sort of the way English law has developed over the last 120 or so years. So that at the time of Shelfer, the view that Lord Brown Wilkinson was expressing was much more of the accepted view, which is essentially if you've done something wrong, we get an injunction. Whereas the way we have now moved, and Lord Hoffman's judgment recognises this, is that where all you're interested in money, an injunction won't be. And that's why in Coventry, this court recognised that essentially Shelfer is no longer the guiding principle. It doesn't mean to say that the 4 points that are made there as to factors that may come into play are discarded. And I think Lord Newburger in particular made that clear. But both, it's clear from Argyll, Coventry, One Step, that in cases where all that somebody is interested in is money, then that's what you should be giving them. But this case becomes an even more important application of that principle when one considers the adverse effects of the injunction. But just before I turn to that, you've also had your attention drawn, which I'm sure you're very familiar, to the enforcement directive. And in our submission, the enforcement directive, and the reason that hasn't been directly implemented in English law is the view is that English law reflects the enforcement directive. So the principles that you derive from Argyll, Coventry and One Step are perfectly consistent with that. Now, the problem in this case is that the way in which the courts below have looked at this is, and again I say this with respect, but they've treated things in a rather simplistic or black and white way, which is they've said, firstly, is the global license FRAND? And they've worked on the basis, and this is the discussion we had yesterday, well, simply because commercial men might compromise their disputes and enter into a global license, that necessarily must always be the case, which we say is wrong. But they then say that hasn't been taken by Huawei, and so it follows an injunction must be given. Now, even we say that they're wrong in their approach to saying that the settled global license was FRAND, and if I'm right about that and they have just got wrong the approach to SC and justiciability, then that is the end of the matter, because in our submission you simply shouldn't have been looking at rates for Chinese patents because that wasn't a matter you could determine. But in any event, even if one says their approach was one that you could follow, you still had to go on and consider in our submission whether it would be reasonable for a implementer to say I only want a UK license, and whether or not you should injunct him if he says I only want a UK license because I want to dispute the rights elsewhere. And as I've already said, the license settled has numerous problems, and we suggest it's inconsistent with ETSI. And the only disadvantage of the UK license is that it leaves the UP to seek to enforce its rights, if it has any, elsewhere. Now, in our submission, when one's thinking about an injunction that I'm going to keep somebody out of the UK market where they're prepared to pay for the UK rights, the purpose of this is because I don't want to put UP to the bother of actually establishing that they have foreign rights. One asks, well, why is that something the UK court should be doing? In our submission, it's just, it doesn't make any sense at all. Now, so there are three particularly egregious points which I draw attention to, some of which I've already made, so I'll just make them very briefly because of the time. The first is you should not be using an English injunction or a UK injunction to obtain worldwide royalties. We've reminded you in our written submissions of the GATT case, which makes it very clear that there's no jurisdiction to consider foreign issues of patent validity, and such issues can't be dressed up. In our submission, it's no answer to say that the courts are only settling a contract. What it's doing, as the Court of Appeal recognised in Conversant, is determining a claim for Chinese royalties. So in our submission, the injunction is inconsistent with the principled approach that one finds in One Step, Coventry and Argyll, and it's in any event inconsistent with the purpose of an English injunction. That's the first particular egregious point. The second is failing to recognise the importance of local court adjudication, and that is adjudication both on validity and as to the value of the rights. And in our submission, again, this is something the English court, even if my view of ETSI is wrong, that the English court should not be doing, shouldn't be saying to a Chinese manufacturer, the price of access to the UK market is that you have to pay a price for alleged Chinese patents, which your home court may say are not there, and where the home court may say is completely different. And that is both distorting competition in this jurisdiction and in China. And in our submission, that is serious overreach.
I can see the point about validity. What about value?
Well, value of the Chinese patents is something which is very much an issue for the Chinese courts. Firstly, there is no value unless they're valid and they have the right scope as well. But how many there are, and that's related to that, but how you value them is a matter, and there are different approaches, that's the point, in different courts to valuation. There isn't a one-size-fits-all, so it's a very odd thing for the English court to say we are the appropriate court to set the value for Chinese patents, when the Chinese court may well adopt a different approach.
Well, that may be a forum conveniens argument rather than a pure jurisdiction argument.
Well, at the moment, it is a forum conveniens argument, but it's also an argument relating to exercising your injunctive powers. And in our submission, it's something you need to take account of as to whether this is an appropriate use of injunctive powers, when the only purpose of it is to say that they don't have to go to China to litigate the matter.
Yeah.
Now, and as I said yesterday, there is a considerable danger in any event in overstating, which is the point that really seems to have driven the Court of Appeal, overstating the cost of having to sue in foreign jurisdictions. I mean, firstly, on our facts, the main jurisdiction is China, where, as it happens, the litigation costs are a fraction of those that pertain here. I don't know why that is. Maybe the lawyers get paid less. But they are. And the reality is that on these portfolios, if litigation took place in China, it is unlikely you are going to need to litigate in very many more countries. But even if you do, one has got to remember this is a field in which we are talking about literally millions and millions and millions of dollars at stake. And don't go away with the impression, oh, well, this is a widows and orphans case where Unwired Planet and Conversant are in that position. They are NPEs who've bought up these portfolios, essentially, I think, owned by venture capital funds, and they are people seeking to make a financial turn. Now, well, of course, the issue is whether they're entitled to, but one shouldn't, as it were, close one's eyes as to what is going on here, and where the UK court is now, if these decisions are upheld, is going to find itself inundated with these types of claim. And the problem of that, I mean, this isn't a fundamental part of my submission, but it is right to note that at the moment there is only one patents judge who is able to try the technical aspects of these cases. That's Mr. Justice Burse. Now, no doubt somebody else may be appointed in the future, but there's unlikely to be more than 2 or maybe 3 patent judges. And if this approach is upheld, one can see that the splintering off of portfolios, using them to leverage in this way, will become a rather attractive game, which is going to completely overwhelm the English court.
Well, that assumes that if we were to uphold the approach of the courts below, that assumes that if we were to uphold the approach of the courts below, that other jurisdictions would not follow suit.
Well, that's the other thing. Of course, alternatively, there are 2 vistas. It's this jurisdiction, or what you have is races round with people trying to just select jurisdictions, or particularly the NPEs, or it may be that the technology companies themselves start to set up licensing companies, seeing there's merit, there's a value in this. But you then get to a situation which is, I mean, it's a very interesting point, where the English court's approach is, well, once you've established a UK SEP, this court is the appropriate jurisdiction, and I will give an anti-suit injunction, which is what Mr. Justice Henry Carr said he would have done, to restrain proceedings in China. And then, if you're right that other courts can do it, you're running the risk of anti-suits and so on. I mean, one's heading for a jurisdictional nightmare. Now, the final point is public policy, and first, it is important that patents are subjected to proper scrutiny. There's a public interest in that, and that's not just UK patents. So, I mean, it is a rather odd, it's a paradox of these cases that the UK patents are subject to full scrutiny, but not the foreign patents. Now, what on earth can justify that? But the effect of this, particularly if people are required either withdraw from the market or are required to pay excessive sums, obviously has potential effects on competition, on consumers, and the points are fairly obvious. And we suggest that in the Unwired Planet case, the courts have gone substantially wrong, and the correct approach is what was reflected in Mr. Justice Burse's first and second and third thinking, and therefore the injunctions in the form of this case should not have been granted, and indeed that would be the end of the matter, because Huawei has paid the English license rate. Indeed, it's paid much more than that injunction. I'm now going to move on to forum non-forum in the Conversant case, unless there's anything I can assist you with further on that point. Now, in Conversant, the questions arise at a jurisdictional stage. And at the jurisdictional stage, we say that the court should have declared that it would not try Conversant's claims, should have refused permission to serve Huawei China out of the jurisdiction, and granted the forum non-conveniens stay application. Now, we say that for two reasons. Firstly, the claims in substance are non-justiciable, for the reasons I've already explained, and secondly, in any event, because England is not the forum conveniens. Now, the claims, I'll need to explain a little bit further why they're non-justiciable in this context, but the claims are, I explained to you yesterday, and they're set out in the claim form at app tab 2, tab 10, MS 1169, the particulars of claim, app 2, tab 11 at 1176, and they're also recited at paragraph 22 of the Court of Appeal. Now, the statement of case on FRAND pleads that it was and remains FRAND to offer a global portfolio license. That's paragraph 6. And the settled global license essentially mirrors the settled global license of Mr. Justice Burst in Unwired. And I've explained how that works. So what it really is what's called a settled global license is in fact a license for a number of different jurisdictions, but particularly China, which is the predominant one and the one that provides for the worldwide royalties on 75% of the sales. Now, the key dispute in our submission in the litigation is whether it is FRAND and whether the UK court can determine it's FRAND for Huawei to license Conversant's Chinese patents in its country of manufacture and principal place of sale, and in return for worldwide royalties. The key question, in other words, is whether willing licensors and willing licensees the key question, let me put it another way, is whether it is FRAND to require a license of Conversant's declared Chinese patents in return for licensing the UK patents. Now, in our submission, one immediately encounters the difficulty that Huawei says the Chinese patents are invalid. Now, Mr. Justice Henry Carr, at paragraph 18 of his judgment, accepted, as is inevitable, that if the Chinese patents are invalid, then it's not FRAND to seek to agree a license for China, or indeed to seek a license for worldwide royalties, because you could only justify such a license on the basis of having Chinese patents. And we say that the effect of this is that Conversant's claim shouldn't get off the ground. Now, the judge said in Conversant, in paragraph 19, that the defence the patents were invalid would be, if pleaded, struck out. But the claim should nevertheless continue. But in our submission, the consequence of the issue of invalidity being raised makes a claim which is dependent on establishing validity non-justiciable. Now, if we take the position in Germany for a moment, because there are German patents, then that would be the result of Article 24.4 of Brussels 1, confirmed by the Court of Justice in GATT, which is at A5 102. That's worth turning that up. It's at MS 7506.
Sorry, MS?
I'm sorry?
I didn't hear your number.
It starts at 7506.
Thank you.
My Lord. And the relevant part, I'm not going to spend time obviously reading it out, is at page 7513, paragraphs 24 to 28. Finally, paragraph 31, and particularly note that the answer to the question referred must be that the then Article 16.4 is to be interpreted as meaning that the rule of exclusive jurisdiction laid down therein concerns all proceedings relating to the registration or validity of a patent, irrespective of whether the issue is raised by way of action or plea in objection. Now, if Conversant had sued for damages for German patent infringement, there's no question that Article 24.4 would apply when Huawei disputed the validity of the German patents, and the English court would have no jurisdiction over the German aspect of the claims and would have to confine itself to UK patents. But it doesn't matter whether reasonable business people would agree to license German patents. Article 24.4 still applies. And it doesn't matter whether the English court can fashion its order in such a way as to provide for a mechanism for the defendant to be protected if it subsequently shows invalidity in the German courts. The jurisdictional bar applies nevertheless. It also wouldn't matter if the English court is asked to rule on an assumption that the German patents are invalid. And that's the decision of Mr. Justice Arnold in the Anand Kasai case at A1 tab 5 MS 4123 paragraph 25. Don't need to turn it up. Now, we say exactly the same applies to a FRAND issue. The contention that it is FRAND to license patents in other European countries becomes non-justiciable and subject to jurisdictional bar under Article 24.4 when the defendant disputes the validity of those patents and says they're invalid. And for that reason, it's not FRAND to license them. As the ECJ said in GATT, Article 24.4 applies whatever the form of the proceedings, whatever the way the pleading is formulated, and whenever the issue of validity is raised. The aspect of the case concerning validity can only be resolved in the courts of the country granting the patent. So that's the position within the EU. And we say precisely the same applies at common law, where the disputed patents are non-European. The jurisdictional bar arises not simply because patent infringement is pleaded, or because the licensing of foreign patents is said to be FRAND, but the moment the defendant raises the issue of invalidity. And that you see quite clearly in patent infringement cases such as Potter, coin controls, and the well-known US case of VODA. And indeed, I showed you yesterday the US District Court's judgment in the Optus Wireless case, where they said it's hard to see how the reasoning in VODA wouldn't apply to the FRAND claims, and we say it does. So just as Conversant cannot sue for damages for Chinese patent infringement, where the validity of those patents is in dispute, so it cannot sue, or it's not forum conveniens to sue, for a China FRAND license or contend that such a license is FRAND, where the validity is in dispute. Now, this is true of all the foreign patents in the license, the major markets and any other foreign patents too, the validity of which are all in dispute, but it's the Chinese patents that overwhelmingly count the most. So, in our submission, the court should rule that since and so far as Conversant contends that a settled China license or a settled global license to disputed Chinese or foreign patents is FRAND, the claims are not justiciable. They're beyond the subject matter jurisdiction of the court by reason of Article 24 and the common law rules. And this reflects, in our submission, the sound administration of justice and the institutional allocation of exclusive jurisdiction to the courts of the country of grant, in all cases concerning validity of foreign patents. And in our submission, you should not be trying to use FRAND licensing to circumvent the bar on foreign patent infringement claims where validity is in dispute. In our submission, that means that Huawei's justiciability or subject matter jurisdiction challenges should succeed for the claim that a China license or a global license is FRAND, and for a claim for a FRAND injunction, that is to say, a UK patent injunction unless such license is agreed. But that does not mean they are barred, as the respondents seek to say, we are saying, from suing on their UK patents for UK relief. But they don't want to do that. They have no fallback claim in the Conversant case that a UK license only could be FRAND. Their case, and the only case they're interested in, is that the only license it can be required to offer is this global license. It says that at App 4, tab 60, paragraph 9. And as Mr. Justice Carr, Henry Carr, noted at paragraph 66, although he said the claim for infringement was a matter of substance, not form, he then said the object of the proceedings is to obtain the relief sought in the claim form, either a global FRAND license or a FRAND injunction. Now, the reality is that all that is happening is that they select a UK SEP, no doubt because of, and this all followed from the Unwired Planet case, and they think, well, based upon Unwired Planet, I can use that as the golden ticket to get the English court to require this global license. But which SEP or alleged SEP they choose is purely a matter of happenstance. They're not interested in any rights for in the United Kingdom. Now, as I've already said, the Court of Justice in GAP said Article 24 applies whatever the form of proceedings or pleadings. Secondly, the respondents have no interest in an injunction in itself. Thirdly, damages, UK damages, are not an object of the proceedings. So in substance, the claim is a claim to enforce foreign patents, in particular Chinese patents, and are non-justiciable because the validity of those patents is in dispute. Insofar as they wish to pursue their claim on the UK patents for UK royalties as damages for UK patent infringement, and an injunction restraining patent infringement unless a UK license providing UK royalties is agreed, then that would be a different matter. Now, forum conveniens, we say that in any event, even if the court doesn't accept what we say about Article 24.4 and the common law, the court should find that permission to serve Huawei China out of the jurisdiction should not have been given, and the claims against Huawei UK should be stayed.
Am I right in thinking that really one only gets to forum conveniens, or your submissions about forum conveniens, if you're wrong about justiciability?
Mm-hmm.
And it certainly helps me, I think, to think of forum conveniens on that hypothetical assumption.
Yes, you only get there if you say that a FRAND dispute falls into a different category to what's being described in GATT.
Yeah.
And so therefore the English court can decide that. Then, so in other words, you have, as it were, subject matter jurisdiction, but then you come to the question, where is the appropriate case to try this? And in our submission, it's at that stage you have to look at what is the true character of what is the correct characterization of the dispute. Now, in our submission, it's very difficult to see how anyone sensibly can say this is anything other than, in substance, a Chinese patent infringement or licensing case. The pleaded claims of UK patent infringement are simply a hook and no more for a declaration that a Chinese license or a worldwide license is FRAND. The pleading itself puts Chinese patents at the centre of the case. And of course, in a forum conveniens issue, one needs to take account of the whole case, including the points raised by the defendant. And the accepted relevance of Chinese patent infringement or non-infringement and validity or invalidity is central to the issue as to whether or not a license is required for the Chinese patents. Now, as a matter of fact, and it is an important point once one's looking at this at forum conveniens, the conversant itself never regarded the dispute as relating to a UK patent dispute. They had 3 years of negotiations in China prior to these proceedings, and those negotiations all concerned the Chinese patents. There wasn't any, or the complaint was that they weren't being paid a worldwide royalty. The subject matter of the complaints was not, oh, you're in England and we've got a UK patent. And conversant says we're confusing their commercial complaint with their legal complaint. But what it shows is that their legal complaint, the UK injunction, is simply a device following Unwired Planet in order to try and get this court, rather than the Chinese court, to decide the issue. Now, you've seen the reaction of the Chinese court to that, and they were entirely right. It was a measured reaction, and it's a reaction which one would think any court in their position would take, that the English proceedings are designed to avoid us, the appropriate court, looking at the issue. And we know what has happened when the appropriate court has looked at the issue. It's found that the 11 patents that are were relied on at the jurisdiction challenge, every single one is a dud. They put forward 4 more, and 1 has survived subject to validity. Not a very good track record. And so in our submission, China is clearly the appropriate forum, and indeed the only forum that can actually decide the issues relating to the Chinese patents. Now, next point is finality of justice favours the English court not getting involved. We say, and we don't understand how the contrary can be said, that the Chinese court's decision on validity and on royalties is will be dispositive. But if one's going back to the stage at which this argument originally arose, the English court's decision, particularly in the light of the way if one approaches it, that they're only making some sort of provisional determination, which I've already explained why you can't do that. But even if that's all they're doing, then it's not going to be dispositive of anything except for the determination of the UK rates. Because if you're saying, well, everything else will have to take account of what is done in the foreign courts, you're not deciding anything other than what you should be deciding, which is what falls within your jurisdiction. Now, in fact, as you know, at the time of the jurisdiction application, there were pending proceedings before the Chinese court. And that was all the more reason for the courts to say, well, the Chinese court is seized of the matter. On what basis could it be proper to say that isn't the appropriate forum or that the UK court is appropriate? Now, of course, the decision in the Court of Appeal, at that stage, the parties did not have the benefit of the decision of this court in Vedanta, which I suspect everybody is very familiar with. But the position that was noted in Vedanta at first instance was having two trials on opposite sides of the world on precisely the same facts and events is unthinkable. Well, in our submission, it's even more unthinkable in relation to Chinese patents. But the particular point that we draw from Vedanta is that in this case, when one's at the forum conveniens stage, an argument that's made against us is, oh, well, we're suing Huawei UK. They're in the jurisdiction, so we can sue them as right. They're the anchor defendant. Those proceedings will continue anyway, and so if you can't send things off to China because there's a risk of inconsistent findings. Now, that was very much the Vedanta, an issue that arose in Vedanta. Now, here we say that doesn't trump anything for a number of reasons. Firstly, they, conversant, are selecting the English action, which is an inappropriate forum to determine the real issue in dispute. But secondly, we have agreed that everything can be tried in China on the basis that Huawei will agree to not dispute validity of the non-Chinese patents, and the Chinese court can determine essentiality, infringement, and FRAND terms. So, insofar as they are seeking royalties on sales other than the 15% that are in China, then the Chinese court can determine that. That agreement, for your note, is at App 4, page 1599. Now,
what I'm not quite clear about is where the evidence currently stands, or the admissible evidence currently stands, as to whether in the light of that agreement, the Chinese courts would go then and determine a global FRAND license and settle a global FRAND license. It's one thing to say, well, as in Vedanta, the Zambian court could have dealt with the whole dispute. And therefore the real reason for conflicting judgments was because the London-based defendant was refusing a proffered agreement to submit to the Zambian court's jurisdiction. There was no doubt then the Zambian courts would deal with the whole case. But here there is a doubt, and I'm not quite sure where the evidence has got to in terms of resolving it.
Yeah, I'll address that. But let's assume against me for a moment that the Chinese court is not capable or not prepared to determine well, it depends what it is you say that they would be doing, but
Well, settle a global FRAND license.
I don't. There's
works for me anyway. The concept of settling a global FRAND license.
The Chinese court, if we just take it in stages, awards. I think one needs to be careful about terminology. There's no question that the Chinese court, as the court of at the place of manufacture, where there are Chinese patents, can determine a royalty rate which covers 100% of the sales, because everything is being done in China. So the only question arises so that is in fact a global royalty. The only question arises is whether the Chinese court will also determine a royalty rate applicable to, say, a UK patent and a German patent, and do it on some other basis than the Chinese rate. So there are two possibilities: that the Chinese court simply adopts a monolithic approach and says it's the same royalty rate, whatever you're talking about in all markets, or whether it adopts the approach of looking at the rates applicable to different markets. Now, the position is that the judge said that the Chinese courts might not apply foreign law to the non-Chinese patents. That's what he suggested at paragraph 62.1 of his judgment. And he appeared to think that was common ground amongst the Chinese law experts. But that's actually not correct. What the expert said was that the Chinese court would apply Chinese law to the Chinese patents. Not a very surprising thing. Now, what you do have before you, and this is recited in paragraph 48 of the judgment of the Court of Appeal, are the Guangdong Guidelines, which we say do make it clear that the Chinese court will consider applying the local laws of the place where protection is declared. That is
This is the pilot scheme in the court, which, as I understand, has now been shut out of the group of courts which would deal with the claim anyway. That's what's being said against you.
Sorry, I can't.
This is the pilot scheme. This is what's being said against you. It's a pilot scheme published by a court which wouldn't be involved in the case anyway.
Well, that's... Can I come back to you?
Yes.
If you go to the Court of Appeals judgment at if you go to MS page 567. 567. See, at paragraph 61, there's a recitation of Mr. Layton's submissions. And then it said that the judge had concluded the evidence established that the Chinese court could set the terms of a global patent license by agreement between the parties. Yeah, and also at paragraph 122,
well, that was the
MS 580, so, with the consent of the parties, the Chinese court, everybody accepted, can do it. And the issue that was actually being debated was, what if they don't consent? Can it anyway do it? But in our submission, the point, therefore, that doesn't create any difficulties, because we have invited Conversant, when I say we, Huawei has invited Conversant to have the issues adjudicated in China. Now, it doesn't want to do that, and whether or not the Chinese court can force it, what Conversant can't say, because I'm refusing to have all of this decided in the court which is predominantly concerned. Therefore, the English court somehow becomes an appropriate jurisdiction. And the final point I make under this head, that even if it's right that the Chinese court, and there isn't evidence that shows this is the case, but even if the evidence was, the Chinese court would apply Chinese law to, for instance, the question of damages, or adopted a monolithic approach. In our submission, that doesn't follow from that you're not obtaining substantial justice. It just means that one party is saying a forum is more advantageous to me than another. Now, in fact, if by consent the whole dispute went to China for royalties for all of the alleged patents, the Chinese court, the effect would be the Chinese court would decide whether there were any valid patents in China, and the Chinese court, the parties would then be proceeding so that Conversant would get an advantage in that their foreign, non-Chinese septs would be assumed to be valid, which is a pretty favourable assumption in the light of the track record, and potentially, therefore, get royalties for those if they could get over the essentiality hurdle, which they may well not hear, bearing in mind their strike rate here.
I'm sorry to be difficult, Mr. Howard. I'm really quite perplexed as to what your submission is. Are you saying that the judge in Conversant did find that the Chinese courts would accept jurisdiction to settle a global FRAND license if there was consent that they should do so? I know that's what the Court of Appeal records as Mr. Leighton's submission in paragraph 61 of their judgment. But if you go back to 61 of the late Mr. Justice Henry Carr's judgment, he doesn't seem to reach that conclusion at all. Page 859. I'm not sure the Court of Appeal was doing more than recording Mr. Leighton's submission, although I see what you say about paragraph 122.
Yes. Which, sorry, you were saying...
Well, I'm looking at 61 of the judge's judgment. He says the furthest evidence goes to say if Conversant were to agree that then the Chinese courts might or would accept jurisdiction. No reason to advance support that the would accept jurisdiction conferred by agreement to determine infringement of UK patents and set a global FRAND rate. No evidence has ever been done in China. It's rather tentative and speculative.
I mean, that is probably a fair recording of the evidential position that it hasn't been done before in China.
But that was the judge's judgment on the facts that were on the evidence that was presented.
His conclusions at 64 leave aside the question of infringement, but in my judgment, China is not an alternative.
Yeah.
Said.
Well, that's a conclusion. But
that's where it gets to on the evidence before him.
Yes. But you have to break it down. I mean, firstly, before one gets there, what one's got is the essence of the claim. The unavoidable point is the essence of the claim is a royalty in respect of the Chinese patents and Chinese sales. I mean, the global nature of this only comes from China, because, as I've already explained to you, somewhere between...
I think really, just to cut in, I'm sorry.
No.
That's what he's found.
Yeah.
So to disrupt that, you have to go behind that.
But I'm saying you have to analyse what it is you're talking about. Mr. Justice Henry Carr is not saying the Chinese court can't determine a royalty for Chinese patent infringement.
No.
That's the first thing. And Chinese patent infringement is the only thing that is relevant for 85% of Huawei's sales, because, let's say it doesn't matter whether it's 75 or 85, because those are sales which either only take place in China or take place in countries where conversant doesn't allege it has a patent. And so that aspect of the dispute can be determined in China.
That doesn't include the UK patent.
No, that you then have the UK patent, German and some others, and so you're then left with the question at a forum convenience stage as to whether or not, nevertheless, you should bring Huawei China to the UK. Now we say, let's assume, against me for a moment, that the Chinese court cannot decide the UK and the German rate. Let's assume that against me. My submission is it is still wrong to serve out of the jurisdiction Huawei China in order to get a determination of the Chinese patents and the Chinese rate, so that whatever else, that should have been carved out.
Well, carved out or put on one side. If the claim is, I want a global license to be settled, I want a declaration as to what that a global license is the right kind of license, and B, I want it settled by the court in the event of dispute, which I think you say is the primary claim in conversant.
Yeah.
And that's not out with the English, it's not unjusticiable, because this is the hypothesis on which we're looking at.
We've lost on those points.
But why isn't the solution to the proposition that the Chinese courts hold the key to a central issue which will take you a long way, but not all the way towards a global license, settled terms, case management?
Well, it's because of the form of relief, and it's that the form of relief that's still being sought is that the English court should determine the Chinese royalty as part of the
claim is not that they should determine Chinese royalties separately, but they should determine a global license, which includes royalty rates, which will be some sort of aggregate of Chinese royalties and other royalties used as a top-up. Well, not an aggregate, but I mean some sort of combination.
Well, it's just, this is the rate for China. The Chinese rate isn't determined by saying, well,
no, sure.
You've got patents elsewhere or anything of that sort. It's just looking at what rights you have in China. You can look at it another way. Assume you are seeking leave to serve out, where you say, I'm asking the English court to determine a rate. If you break it down, you say, I'm asking leave to serve out in order to get the English court to determine my rate for the United Kingdom and for China. So you don't call it global. You say, I want you to determine that, and I want to get leave to serve out on Huawei China to determine those two questions. Now, in my submission, one would be entitled to say, I'm not giving you leave for the Chinese point. That you don't need, and it's not appropriate for the English court to do that.
But your own submission is that the substance of what conversant are trying to get is not a Chinese rate for China, but the settlement of the terms of a global license.
No, my submission is they're calling it a global license, but the reality is, the reality on our facts is that they are seeking a determination of the Chinese, determination of a Chinese royalty on patents which can only be decided in China. The rest of it is if you like, if you look at their license that they're seeking, I think they've got China plus 9 other places. 9, I think they've now put it up to 11. So what they're asking the court to do is to settle, you actually have a rate, which is the so-called major markets rate, and the China rate. Might be worth just looking at it.
Well, okay, but
Well, we've seen it yesterday. I don't want to.
I think I understand the essentials.
Yeah. So that's actually, the essentials come down to saying, I have got 2 or more, or 3 or more, whatever the number is, declared SEPs in each of these major markets. And this is the rate for the major markets, and I want a rate for China. And so, however you look at it in our submission, there is a substantial part of what they're claiming for a Chinese license. Might be tied in with something else, but in our submission, the obvious place that should be trying that issue, what is the rate for China, is China, if you get to this stage in the argument.
But whether you exclude the Chinese element at the point of the application to serve out, or whether you allow service out, but as Lord Briggs says, stay the Chinese element to allow a decision by the Chinese courts, which I think is the point that was being put. Either way, you, in a sense, you win.
Yes.
Yes. But you prefer the former, not allowing any service out of the Chinese element. Yes.
I do. I mean, I say that it is if you broke it down in this way, if you assume they were only China, it would be very easy, assuming say it was just a royalty for China that they sought. It wouldn't be very difficult to say, well, in that case, China is obviously the appropriate forum. In our submission, it doesn't make any difference that you tack on and say, I want a license for the United Kingdom and Germany and the Netherlands. You still have to look at that claim and ask yourself, is it appropriate for at least that element of the claim to be brought before this court? And in my submission, although case management is just, to use a fashionable expression, kicking the can down the road, it's meant in terms of the Brexit discussions. It seems to be the language that we hear constantly being spoken about. But the fact that one's recognising that you'd have to case manage it in that way is ducking the question, should I be bringing Huawei China here for this determination? If one says, well, no, I'm not going to determine it, the Chinese court is, then it's not really a question of a case management stay. It's saying that isn't part of the English case.
But the argument against you, as I understand it, is that if, following Mr. Justice Carr's analysis of the facts, the UK is in fact the only forum which will settle a global license, brackets including China and all the other major markets, and you can't get that in China, then it's not a forum question, even though what you can get in China will be a swift, probably cost-effective and, on any view, reliable way of dealing with the main issue in your global license.
Well, of course, the way your Lordship has just put it to me actually reveals the oddity in what is going on here, and it goes back to the sort of substance of all of this. If one starts with the proposition the English court is the only court that can do this, that it might indicate something is going badly wrong.
Well, it might, but we're working on the hypothesis that it is just discipline.
No, but I'm saying your Lordship's question, in a way, reveals the flaw in the whole exercise.
But it's the hypothesis on which your
no, it does, but I'm just,
argument is based.
forensically, I'm just pointing out that it does rather raise the flag as to what on earth is going on here, that this court has set itself up as the international court where nobody else can do it. There's no convention that I'm aware of that allows this. I mean, in my submission, it's just an extraordinary state of affairs. Can I just say something about the UK anchor defendant? The first thing is, the UK anchor defendant is as its nature suggests, just the company that sells phones in the UK. So it's difficult to see, if you were only suing the UK anchor defendant, why you would ever be able to seek or establish your global license. But secondly, we say there's no risk of inconsistent judgments, either because of the Vedanta point or because the claim against Huawei UK shouldn't deal with the Chinese patents, and so that would avoid that. And thirdly, it's common ground you could have a case management stay against Huawei UK. I think that's all I want to say on that aspect, and I want to just briefly, but it will be brief, make some submissions on non-discrimination.
But just before you do that, it's just for a point of information, it has struck me in the last few minutes sitting here that the issues in this case are of such international commercial significance and also have a certain diplomatic significance that it's a kind of case where one might have had an intervention either from our own government, say the Department of Trade, or from other governments, such as the Chinese government. As I don't know if the parties, if anyone, have notified these proceedings to any interested governments. Yes. So it might have been useful to know what, for example, our own government thought of the idea that we should be exercising the sort of jurisdiction that you're describing.
What one can, I mean, obviously I can't speak for the UK government, and they're obviously slightly distracted at the moment, but that's assuming we have one. But what one can see, and I do say this is an important policy point for the court, is that the potential effects on the UK market are extremely important. And what one's setting up is effectively either a price for coming here or a barrier at which and the price is maybe inconsistent with actually what are the correct rights in here. China, saying to a Chinese company, the price for your coming here is that you've got to pay royalties on the lion's share of your sales, which are in China, in respect of Chinese patents, which your home court might not agree with. And in my submission, that's a fairly dramatic thing to be doing, particularly in terms of an economy which is supposed to be open and so on. The points perhaps are too obvious to state. Turning to non-discrimination, so this is an entirely, as it were, discrete but important point, which arises in the Unwired Planet case, and the Court of Appeal described it as a fundamental dispute between the parties as to the interpretation of the non-discrimination requirement in FRAND. It's essentially what is the meaning and effect of that term. What do you mean by non-discrimination? It's what it comes down to. Our submission is a hopefully straightforward one, which is that the ordinary and natural meaning of the expression non-discrimination or non-discriminatory terms is that like situations must be treated alike and different situations can be treated differently. And that means that the SEP owner must treat all similarly situated licensees in the same or a similar way, unless there's some objective justification for doing otherwise. Now, the reason that this issue arose was that in July 2016, shortly before the FRAND trial, Unwired Planet granted a license to Samsung of exactly the same portfolio as is in issue in the Unwired Planet case. The rate granted to Samsung was much lower than the rate sought from Huawei and ultimately that the judge orders. The exact numbers are set out in a confidential annex to the written case, which I think your lordship should have, although they're not in the court bundles. But from the public materials, it is evident that the Samsung rate is more than 3 times lower than the benchmark rate set by Mr. Justice Burse. And you see that at 494 of his judgment at MS 738. Now, Mr. Justice Burse did find that Samsung and Huawei were similarly situated on any view, and he did find that the license granted to Samsung was an equivalent or comparable transaction to the putative license that was being considered, the one between Unwired Planet and Huawei. There was an appeal against that, but that was dismissed. So against those findings, we say that the judge and the Court of Appeal should have found that the non-discriminatory rate that UP could charge Huawei, is on the basis one's looking at this global license, was no higher than the rate it had granted to Samsung. And in our submission, that's the very essence for non-discrimination obligation on any ordinary understanding of the concept. And to say that Unwired Planet could charge Huawei a rate higher than the rate it charged Samsung without discriminating, we'd suggest is not possible as a matter of ordinary language. Now, there were 2 theories of the courts below on this. There was what's called the general non-discrimination, which is what Mr. Justice Burse put forward and the Court of Appeal agreed, which is a licensor is free to discriminate below a fair and reasonable benchmark to be set by the court. So in other words, what that amounts to is, if you take Huawei, providing the rate that the court sets is fair and reasonable, then Unwired Planet can offer that, but they can offer Samsung a special, as it were, mates rate, which might be 2/3 of that. And that's, according to that, not caught by the non-discrimination. The second approach was found of Mr. Justice Burse, but the Court of Appeal didn't have to rule on it, because they said his general non-discrimination was right, was that the obligation not to discriminate could only be enforced if the difference between the 2 rates being offered would distort competition between the 2 licensees in the sense applicable under Article 102C. Now, we say neither of those is correct, and we say, by way of submission, that there are three points that we make. The first is the clear and unadorned wording of the FRAND obligation. The second is our submission is consistent with regulatory decisions and foreign cases. And thirdly, our approach is straightforward and practicable, whereas the approach which the courts below have suggested would render the non-discrimination limb extremely difficult to enforce in practice. As to the wording, of course, the FRAND undertaking is a contractual obligation in an internationally applicable document which is governed by French law. And in our submission, it's extremely important that the English court doesn't read in qualifications which are not to be found on the face of the obligation. And that's true whether you approach it by reference to French law or under the principles applicable to international arrangements. The evidence relating to French law interpretation principles is contained in Professor Libschaber's report, which is in App 3, tab 28, page 1081 at MS 1554. I don't think we need to turn it up because he says, rather unsurprisingly, that essentially you read the words on the page, rather basically what you would expect in any sensible system. And then there's questions about where words are unclear, the extent to which you can admit other evidence. But we're not in that situation. The second point is the approach to international agreements. And I would refer you, again, I don't think we need to turn it up, but to the decision in the Mitsui case, which was about the York-Antwerp rules, and it's at Authorities 2, tab 44, and it's MS 5378 at page 825. And at paragraph 29, Lord Neuberger emphasised the particular importance of adopting a straightforward approach to the interpretation of a document which will fall to be interpreted and applied in numerous national courts. And you should use unadorned language were his words. And in our submission, the same logic applies here. Now, Unwired Planet attempt to answer this point by saying that our case on what non-discrimination means requires reading in certain concepts in any event. Now, that isn't right. Our case is actually simply looking at what non-discrimination means and as it has been consistently interpreted. Perhaps worth just turning up is the Eggenberger case in Authorities 5, tab 100. Which is MS 7411, decision of the CJEU, and if you go to paragraph 21, which is on page 7408, you can see at paragraph 21 the issue that was being referred was whether particular regulation makes access to the import quota for New Zealand butter at reduced duty more difficult for undertakings not established in the UK and thus restricts free trade. So you had to, if you were applying to import New Zealand butter, you had to make your declaration in the United Kingdom rather than elsewhere. And if you go to page 7411 at paragraph 33, the court said that, as a preliminary point, according to settled case law, the second paragraph of Article 34.2, which prohibits all discrimination, is merely a specific expression of the general principle of equal treatment, which requires that comparable situations must not be treated differently and different situations must be treated alike unless such treatment is objectively justified. And in our submission, that's what is the accepted meaning of non-discrimination. So our approach is simply giving the concept its ordinary and natural and accepted meaning. Whereas the approach, the so-called general approach in our submission, is difficult to reconcile with the words. Essentially, the approach of the Court of Appeal and Mr. Justice Burse treats fair and reasonable as being the operative words, and non-discriminatory is left out of the picture. And indeed, the Court of Appeal effectively acknowledged that at paragraph 200 of their judgment. And on the Court of Appeal's interpretation, it would be perfectly permissible for Unwired Planet to license the entire industry, except Huawei, at the Samsung rate and then charge Huawei a far larger amount, as long as that fell below the fair and reasonable cap. In our submission, that's precisely the opposite of non-discrimination. As to the competitive distortion test, the second approach of Mr. Justice Burse, in our submission, he was right in his judgment when he said that the boundaries of FRAND and competition law are not the same. And that being so, it's difficult to see how one could then suggest that non-discrimination part of FRAND was coterminous with Article 102C. Now, as to the second point I make, the foreign cases, Germany, we've already looked at the proceedings in Germany between Unwired Planet and Huawei. They're at Authorities 8, tab 137, which is MS 9310. So, yeah, sorry. The position in Germany in the litigation between the same parties, it is clear, and concerning this same question, although there it's the German patents, entirely endorses, or the German court entirely endorses our position. The critical part is at 9388. Paragraph beginning with the very first license transaction. And essentially, the German court's view is that the non-discrimination requires the patent owner to treat people who are in the same situation in the same way. The fact that this is the view of the German court, if the English court's approach, if this court said the English court's approach was correct, that would reinforce my primary submissions, because it would show that the approach the German courts take to the matter is, on their interpretation, is different, and that the royalty rate in Germany granted by the German court would be a different rate. China adopts the same line as Germany, and you get that from another case concerning Huawei, called Huawei and Interdigital at Authorities 5, tab 104.
Page.
It is page. Beg your pardon? My friend says that's been set aside. Okay. I'm not sure on this point. Right. Well, I'm told it's set aside, but the outcome of it was. Let me just give you. We can check what the position is. The relevant page, the statement of law, is at 7611. That's the important point of what they say about the law. And the paragraph beginning regarding the issue of non-discriminatory terms. Then, finally, I won't I won't spend time turning it up. The USA, in the TCL and Ericsson case, which we looked at earlier, which is in tab Authorities 8, tab 136 at MS. I've got the wrong reference. it's MS 9195, and at 9248 is the summary of the approach, and essentially they make it clear that the approach entirely accords with what we saw in China. So at page 9285, they say there isn't a competitive harm problem, a competitive harm requirement, and at pages 9287 to 9, what one sees them doing is doing a comparison with licenses which are for people who are similarly situated. In other words, they adopt exactly the same approach, and you see that on page 9307, where basically you have to offer the same rates to people who are similarly situated. So in our submission, those all speak with one voice. Thank you. And the final point is that the interpretation suggested by the courts below would be difficult to operate in practice. In our submission, a non-discrimination provision it's intended to be simple, and it is meant to be analogous to having a price list which is accessible to all, at least all in the same situation. The problem with Mr. Justice Burse's approach, where he sets a benchmark which, and the court sets that, is very difficult for the parties to know, well, what is the non-discriminatory rate if you're just in a negotiation. In our submission, it's meant to be quite simple. You simply say, well, what are the rates that you've offered to Samsung? They're in the same position as me. Equally, the competitive distortion approach would require an economic investigation of the type that one gets in Article 102 cases, which couldn't have been intended. So we say, in this case, the matter is quite simple. And we say we shouldn't get to that stage, if one got to that stage where one was considering the issue of non-discrimination, then the terms that were settled should have been no less favourable than the terms that had been entered into with Samsung. So those are my submissions, unless there's anything else I can assist you with.
Thank you very much indeed, Mr. Howard.
Yes, the Huawei ZTE point, we don't wish to add anything beyond what we put in writing.
That's not
dropping it. It's just
we,
you're resting on your written case.
Exactly.
Yes, Mr. Bloch.
Lords, my lady, I'm aware that we are overrunning by a little more than an hour, and this is a case in which it will be desirable to have some time in reply. So I will endeavour to see if we can make up some time. I apologise if that means that my submissions may be more disjointed than they otherwise would have been. I had planned to take as my starting point a simple proposition. The terms under which implementers practice under the patents of other countries may be of a legitimate concern to those other countries. My learned friend Mr. Howard has developed that, and I don't think I need to develop it further, it is perhaps obvious. What I will do in order to put in context the submissions that I wish to add to those that have been made on behalf of Huawei is just to note, without developing, some of the points that have already been made. First, as Mr. Howard has shown, a FRAND injunction puts an implementer to a choice. Either it enters into a license or it ceases to operate in the territory. Where the court in this country declares the FRAND license to be a global license, the price which the implementer must pay to continue to operate in this country is paying royalties on its operation in the rest of the world at rates fixed by the court in this country under the laws of this country. So as has been shown, a FRAND injunction granted in this country may affect the cost of operating in other countries, and that clearly is a matter which may be of concern to the other countries whose socio-economic policies may be affected thereby. The problem with the law as it stands is that it provides no satisfactory basis on which the court may decline to exercise jurisdiction over a global dispute as to the terms of a FRAND license or licenses, however little connection the dispute may have with this country, and however much the dispute may impinge or impact on the policies of or activities in other states. In our written case in chief, we have sought to identify what we say are the three tools of restraint that are available but appear, at least as far as the decision of the courts below, not to provide a solution to this problem. Justiciability, forum convenience, and, of course, case management. We maintain that written case, but we seek to focus on forum convenience and case management. The solution to the problem which ZTE advocates may not be quite the same as that which is advocated on behalf of Huawei, and the outcome which we say is appropriate is that which we set out in paragraph 84, subparagraph 10 of ZTE's written case in reply. I don't seek to take my lords to that in the interest of time, but I will give you the reference. It is in the supplemental bundle at tab 3, hard copy page 25, MS 10458. It's an outcome which does allow for the determination of global licenses in appropriate cases where there is agreement between the parties, and possibly in appropriate cases even if there is not agreement between the parties. And we contend there is a principled basis on which the court can do this. In other words, a principled basis on which the court can declare FRAND terms in respect of other territories in some cases, and at the same time decline to do so in others. And the foundation of the solution which ZTE advocates lies in three things. First, an appreciation of the role which the court has in defining the substance of FRAND. Second, an appreciation that FRAND is a process, not just an outcome. And third, an appreciation that a patentee who gives a FRAND undertaking no longer has an unqualified right to exclude others from practicing under it. My lords, my lady, I want to start, before developing those points in a little bit more detail, to say something about what we accept by way of common ground with conversant. There are 3 points relating to the nature of patents, the nature of the FRAND undertaking, and the relationship between that undertaking and the license which it contemplates. So far as patents are concerned, we accept they are a form of property. We accept that an unencumbered patent affords its owner the right to exclude others from practicing the invention which it discloses, at least that is the traditional analysis, and we accept that an injunction may be the appropriate remedy in respect of ongoing infringing activities, even where the patentee is a non-practicing entity. In saying that, and we're not there going into the detail of when that would be appropriate, I do not seek in any way to undermine the argument that has been advanced on behalf of Huawei. I'm simply noting that it forms no part of the argument which I propose to develop. Second, then, as to common ground in relation to the ETSI undertaking, the ETSI FRAND undertaking is a contractual undertaking governed by French law. The English courts commonly make declarations as regards the meaning and effect of contracts governed by foreign law. And if the court is to take the ETSI FRAND undertaking into account in deciding what the relief to grant in a patent infringement case is, the court will have to go some way to define the meaning and effect of that undertaking. At times in the dispute, it has appeared that the issue was one of whether or not the interpretation of the ETSI FRAND undertaking was itself non-justiciable. That's plainly not the case. We say the court will have to go some way. Whether or not the court can go the whole way to determine the terms of an ETSI FRAND license depends on what determining such a license involves. Until one has determined that, one can't determine whether or not it would involve things which are non-justiciable. As a matter of theory, the substance of an ETSI FRAND license could depend on something which the English court regards as non-justiciable. As a matter of theory, that could be the case. It would be unfortunate. One cannot rule it out without saying something about what is and what is not FRAND. And of course, it is likely that the solution that will commend itself to the court will be one which reconciles what is ETSI FRAND with that which the court can decide. Otherwise, one's in an unfortunate situation where what ETSI has laid down by way of policy is something which this court cannot carry into effect. Thirdly, as regards the nature of the licenses which the undertaking implies, there are two extremes. On the one hand, it may be argued that as the ETSI undertaking is given in relation to individual patents, it requires the patentee to license that patent alone. On the other hand, it may be argued that as global players commonly negotiate global licenses, a patentee is entitled to insist on any license being a global license. ZTE recognizes that patent by patent licensing is unlikely to be FRAND, given the costs and inefficiencies that it could involve, at least unlikely to be FRAND in every case as a matter of principle. ZTE is not just an implementer. ZTE has a substantial patent portfolio, and it is not tempted by the idea that implementers can insist on patent-by-patent licensing in any and every case. It does not follow, however, that it will not be appropriate in certain cases. It does not follow that one goes to the opposite extreme and says that because patent by patent is inappropriate, it should be global. A key question, we say, for the court to consider is how far FRAND is something which the court itself is obliged to fashion, and to what extent it is something which the court is simply looking to determine by reference to something out there, be it in the market or otherwise. Mr. Hard has addressed the court on the consequences of the law as it has been adumbrated by the lower courts. There are perhaps four principal consequences. First, on the law as it stands, the English court will have no option but to determine the terms of a global license in any case where it is shown that one or more valid and essential declared UK patents exists. Indeed, for reasons I will come on to, it is unclear that it is necessary, certainly on Conversant's cases originally put at first instance, that there should be any dispute in relation to a UK patent, or indeed there should be established that there is any valid and essential UK patent. Secondly, of course, as a matter of principle, if the English court considers it appropriate or it is obliged to determine the terms of such a license, if that is what is et FRAND, in any case where there is at issue a single UK patent, by parity of reasoning, it should accept that the same will apply in relation to other courts, and thereby other courts may, on the basis of a single patent within their territory, determine terms which will cover patents in other territories, including the United Kingdom. Thirdly, on the law as it stands, if insofar as the court sets the rates to be paid under foreign patents, it will either have to have regard to foreign antitrust and competition law, or will risk setting rates which do not accord with foreign antitrust and competition law. And of course, fourthly, by parity of reasoning, it would accept that foreign courts would do the same, thereby disregarding or determining themselves the relevant competition law applicable in this country. And it may be worth noting that Conversant is unabashed in asking the court to disregard foreign antitrust law. I will give you the reference, it may not be necessary to turn it up. In its draft FRAND response statement of case at paragraph 16, which is in Appendix 3 at hard copy page 953, MS 1426, Conversant denies, and I quote, that the English court should decline to determine a global portfolio license if the conduct of the licensor is such as to infringe antitrust law of other jurisdictions. Conversant is asking the court to disregard the antitrust law of other jurisdictions. Now, my lords, my lady, ZTE submits that these consequences are undesirable, but the lower courts do not appear to have been troubled by them. The lower courts were untroubled by these consequences, it would appear, for two reasons. First, because of the view that they took as to what amounts to coercion, and secondly, because of how they saw the scope for the determination of factors of foreign law being factored in to the rates payable under a license set by the courts in this country. These are two independent reasons. It would be sufficient, at least so far as the mischief is concerned, for the lower courts to be right about either of them. However, we say that they were wrong about both of them. First, coercion. And I think my lords have already been taken to some of the relevant material here. The lower courts saw the fact that an implementer has the option of withdrawing from the UK market as an answer to any suggestion that the terms of the license might be coercive. We say that adopts a very narrow view of what amounts to coercion. First, where the English court sets a rate in respect of the use of a foreign patent, which is higher than would be set according to the laws of that territory, the English court is forcing the implementer to ask whether the UK market is worth more than the extra royalty that the English court requires the implementer to pay in relation to that other territory. How coercive that will be simply depends on the figures. Second, the fact that the implementer may agree the license does not dispose of the problem from the perspective of the foreign state. If the foreign state has set its terms according to its own socio-economic goals, it will be no comfort to that state to be told that the reason why the parties are operating under a different regime is because they have agreed to it in the context of English proceedings. If, for example, the EU and the UK have different socio-economic policies in the future, neither will be happy with the other making access to its territory conditional on SEP owners and patentees agreeing to operate on its terms across both territories. Third, the fact that it may be open to an implementer to decline to take a license on the terms determined by the court doesn't dispose of the effect of the declaration as to those terms. What the court declares to be FRAND will be res judicata between the parties, at least as far as the English court is concerned. The license will be binding on the implementer if the implementer takes it up, and it may be binding as a matter of English law, regardless of whether or not the terms in relation to foreign patents offend the antitrust or competition laws of the foreign territory it covers. And the fact that the English court is determining the matter may prevent the implementer from seeking a determination of the same issue from the foreign court. And we have seen, in this case, how there has been a threatened indication that were it not for a change of position on behalf of Huawei and indeed on behalf of ZTE, anti-suit injunctions would have been obtained. so far as the anti-suit in relation to ZTE is concerned, I will give the court the reference. One finds the relevant passage from the judgment of Mr. Justice Carr at Core Bundle 2, page 419, MS 892, and the relevant paragraph is paragraph 12, which sets out those things which Justice Carr considered it was not proper for ZTE to be seeking to argue in China, regardless of whether or not, as a matter of Chinese law, the arguments were well founded. Now, the lower courts did envisage things which could be done to ameliorate the risk of offence being caused to other states, and Mr. Howard has taken you to certain of the mechanisms identified both in the Unwired Planet judgments and also in the conversant judgments. But if one were to adopt sufficient mechanisms, any global license would be global in name only. So we would submit that those mechanisms may ameliorate the problem, but at the cost of defeating the objective which gave rise to the problem in the first place. The approach of the lower courts might well have been workable if RAND meant the same thing in Brussels and in London, and the same thing in Brussels and London as it does in Beijing, New Delhi, Taipei, and wherever. As it is, one sees from the material before the court that FRAND means different things in different countries. And in fact, the lower courts have recognized this, but perhaps failed to take it into account. In the conversant case, at first instance, Justice Henry Carr found that the Chinese courts would apply different law to the English courts. At paragraph 54, he notes, and I quote, "In the case of Huawei and InterDigital, despite being shown Article 12 of the ETSI rules, and despite considering the ETSI-FRAND obligation, the Guangdong High People's Court refused to apply French law and applied Chinese national law to the Chinese patents in that case." The reference is Core 2 384 MS 857. And the judge noted at paragraph 62.1 of his judgment, which is at page 386 MS 859, and again I quote, "It is common ground between the experts that Chinese courts would apply Chinese law to the question of the ETSI-FRAND obligation, and this would result in a lower rate for the entire portfolio than would be granted in other parts of the world." So the judge recognized that the different views of FRAND, that there were different views of FRAND, and in fact he went further than that, if I may just make one further point before, if it is convenient, to adjourn. At paragraph 63 of his judgment, he notes that the differences in the priorities of different states may be reflected in their views of FRAND. So he states at paragraph 63, at page 386, MS 859, FRAND royalty rates for Chinese patents have been lower than in other parts of the world, no doubt because China considers this to be in accordance with the current needs of its population. So FRAND is, it would appear, imbued with territorially specific values, which make the application of FRAND to the determination of global licenses otherwise than by agreement between the parties difficult.
Well, if that's a convenient moment, Mr. Bloch, we'll adjourn now and sit again at 2 o'clock.